All right, so we're going to get started here. Looks like we've got a pretty good crowd so far, and I'm sure that people will be joining in over the course of the early afternoon here. So I'd like to introduce myself. My name is Michael Williman. I'm a partner at Wigdor LLP. We are a law firm that specializes in employment law and in particular specializes in representing employees in connection with disputes with employers. And I'm here joined with me today by two of my colleagues who I'd like to have them introduce themselves.
Great. Thanks, Mike. My name is Hillary Orzik. I'm an associate at Wigdor LLP. I've been at the firm for about 3.5 years. I also represent employees in connection with their employment discrimination, sexual harassment, and other employment-related disputes. And then I'll let a third colleague introduce herself.
Thanks, Hillary. My name's Julia Almolay-Sachs. I've been at the firm for about 1.5 years. And I also represent employees in employment discrimination, sexual harassment, pregnancy discrimination matters, and other employment matters. So we're excited to be doing something a little different today.
Excellent. So what is the purpose of today's meeting? So we sent out a flyer for the meeting, of course, but I wanted to kind of give a high-level overview of what we'd like to discuss today. Obviously, there's a lot going on in the world right now, both in the world of employment as well as, of course, the world at large, and some stuff that we've never seen before. And unfortunately, as we've seen from the last couple of weeks of job reports, there are millions of people, unfortunately, in this country that are losing their jobs. And there are also millions of people in this country who are generally in an uncertain situation in their jobs, whether it be layoffs could be forthcoming, whether it be furloughs, whether it be pay cuts. And obviously we're all now, or at least a lot of us are now working from home to the extent that we're not essential. In the last couple of weeks, Congress has passed a number of laws. New York State has passed a number of laws, and other states as well have passed a number of laws to help deal with some of what's going on right now, including to help assist individuals who are in uncertain employment situations or who have lost their jobs as a result of the coronavirus and what has happened. And in addition to these new laws that have been passed, which we're happy to and we're on the line here to answer questions about, we're also going to be discussing about some laws that have already been on the books. There are a number of employment laws that have been on the books from before the coronavirus was even a thing. And a lot of these laws can be used by individuals who have been laid off or who have been subjected to adverse actions in their employment in the last few weeks to bring about positive change in their lives. So we're going to be talking about both the new laws and the old laws, and we're happy to answer questions regarding either of those. So you might be asking, why are you listening to us? And what makes us sort of qualified to have this conversation with you? As I mentioned, our law firm, Wigdor LLP, is a firm that specializes completely in employment law and specializes in particular in representing employees. We represent employees in virtually all of the cases that we handle. The firm was founded more than 15 years ago, and the purpose of the firm from its founding was to represent employees who have been subjected to unlawful actions or who have had the unfortunate circumstance of losing their job or experiencing negative behavior in the workplace. The firm was founded by Doug Wigdor, who oddly enough is today at a virtual mediation for the lawyers who are watching. So we are now doing really everything by video. And he will be here next week, as we put in the flyer and as we'll discuss throughout the day today. We're going to be holding these sessions on a weekly basis for the foreseeable future until we feel as though there's not the need to have them. And he looks forward to meeting everyone virtually next week. I'd like to take you for a moment, if I can get this to work. So in terms of who we are, as I said, our firm, we are Wigdor LLP. We do employment litigation work, and we represent all manner of people who have been discriminated against, who have been sexually harassed, who have been retaliated against, who have lost their jobs due to pregnancy, due to medical conditions, due to family situations, and now certainly due to people who are losing their jobs as a result of what's going on with the coronavirus. A big part of our practice is sexual harassment and sexual assault. It's something that we focus on very heavily, and happy to answer any questions about that practice as well. And in addition to that, we have a blog, which Julia will be taking you through some of the information on the blog, but it really seeks to contain information and articles about the newest trends in employment law. So as I mentioned earlier, no one has quite seen anything like this before, but as a firm being around for more than 15 years, we have experienced situations where there have been mass loss of employment and mass uncertainty with respect to employment. And the primary example of that would be in the 08-09 stock market crash. And one of the terms that our firm sort of coined at that time was the term recessionary discrimination. And I think it's important to kind of understand what this means and what we've seen employers do in the context of tragic events like this. And what we've seen is employers use recessionary discrimination or use an excuse that layoffs need to come or terminations need to be made in order to lay off people and terminate people for unlawful reasons. You have layoffs that are disproportionately women being laid off or older individuals being laid off. You have layoffs that are used as excuses to get rid of individuals who are pregnant or have had to take leaves for disability or to take care of their family. You have people being laid off because of their race, their national origin, their ethnicity, their sexual orientation, their religion. And then you have people that are being laid off who have made complaints during their employment about discrimination, about sexual harassment. People who have rebuffed sexual advances end up getting laid off. People who have blown the whistle on unlawful practices end up getting laid off. And the reason that I raise this is because there are a whole host of federal, state, and local laws that protect individuals from being laid off for these reasons. And so to the extent that anyone has questions about the law in that regard, in addition to the more specific questions about the new laws that have been passed, we invite those as well. So I will stop speaking for now, other than to say this. We're not going to have all the answers. We're going to be pulling everyone's questions in as we talk about the new laws, and there will be questions that we may not have the answer to. Some of these laws just got passed literally, this morning. And so we're working on, getting up to speed, but we're going to answer them as much as we can. Another point on the questions is that a lot of the answers and a lot of the conclusions are really fact specific. And so there may need to be a longer conversation than we can do on a video chat. And obviously, anyone can feel free to reach out to our firm to the extent that they want to have a longer conversation about any particular and specific question or situation. We can schedule a time to do that directly. And also we may answer some questions that were asked this week, next week, as things get more certain. So I will leave it for now to Hillary and Julia, and look forward to answering any questions.
Great. And just before that, I get into the new developments in the unemployment insurance laws, if you have any questions, what you can do is you can include them as a comment in the live chat box, which I believe is to your right. So you can just add your question in. We have someone who is looking at all of the questions and we'll make sure that they get answered. So if you have any question, no question is too small, please include it in the live chat on your screen. As Mike said, there have been a lot of developments in the unemployment insurance law. A lot of them have occurred within, the last 10 days, and there have been more laws that have been passed, just in the last few hours. So I just wanted to give a brief overview of how unemployment insurance law works and some of the recent changes that have been made specifically in response to the coronavirus, that is impacting so many of us. So generally speaking, employees are entitled to unemployment insurance if they lose their job for a reason that's of no fault of their own. So that means that they were laid off because of a reduction, or if their employer found that they weren't necessarily meeting the employment standards. Now, someone who would not be entitled to unemployment insurance is someone who was guilty of some sort of misconduct, right? If they were found to be stealing from their boss, that's an example of something that would disqualify someone for being eligible for unemployment benefits. Now, a lot of people are suddenly looking at unemployment insurance as a way to get income because they've been laid off from their job, or because their job has furloughed them and has only given them, has said, we're going to shut down for the next few weeks. We'll contact you in, 4 weeks, in a month, in 2 months when we reevaluate things. People are also looking to unemployment insurance if they've gone from full-time to part-time. Now, those employees may be eligible for unemployment insurance when they otherwise wouldn't have been. Some other expansions to the law are that they have expanded who is eligible for unemployment insurance. So previously, individuals who were self-employed, who were freelancers, who were independent contractors, these are all categories of workers who previously could not apply for unemployment benefits, who now may have coverage under the new law. So what is the new law that was recently passed? So last week, there was a law passed called the CARES Act. And what the CARES Act did was it, among other things, created a new type of unemployment insurance that workers could be eligible for. Now, this new unemployment insurance, it doesn't replace the old unemployment insurance. So individuals who want to apply for unemployment insurance, you still have to go through the regular application process first. So this new law provides an additional resource of unemployment insurance. Now, what are some changes? So some changes based on the CARE Act of what's now covered is that individuals can be eligible for unemployment benefits if they were diagnosed with COVID or have COVID-like symptoms and are seeking diagnosis, if a member of their household has been diagnosed with COVID, if they're providing for family or a household member who has been diagnosed with COVID and so cannot go to work because they're providing that care, if they're the primary caregiver for a child unable to attend school or another facility that's been closed due to COVID, if they're unable to reach their place of employment due to an imposed quarantine, or if they've been advised by a medical provider to self-quarantine due to COVID, if their major breadwinner has passed away because of COVID in their household, the spouse of that person may now be eligible. If you've had to quit your job as a direct result of COVID, if your place of employment has closed as a direct result of COVID, or if you're seeking part-time employment and then that was affected by COVID, or if you otherwise are not qualified for unemployment benefits and are affected by COVID. So these are all just examples of ways that the new CARES Act has expanded unemployment benefits for individuals who otherwise may not have been eligible to receive them. And we can go into more detail about who is eligible and who is not later, but I just wanted to provide a brief overview of what is now included in the law and what protections are now available for individuals who have lost their income as a result of COVID. So I'll now turn it over to Julia, who's going to talk a little bit more about paid sick leave and other types of leave that are available for individuals affected by COVID.
Thanks, Hillary. Yeah, so in the past 2 weeks, 2 different laws have been passed that relate to sick leave. So one is the federal law, which Trump signed about 2 weeks ago, and one is the New York COVID-19 Paid Sick Leave Act. So mostly we'll be focusing today on the New York law, but there's a lot of overlap between the laws. So we're happy to answer questions. So I am just going to turn over to our blog, as Mike said, and go through a breakdown of the New York law. So hopefully you guys can all see this is our blog. And so this is just generally, we have a bunch of different blog posts here, and this is the breakdown of the sick leave law. So the first question one might ask is, how do I become eligible for paid sick leave under this new law? And so in New York, it depends on how big your employer is and how much money your employer netted in 2019. So you're eligible if you worked for a company with more than 10 employees, or an employer who made more than 1 million in 2019. And you're also eligible if you worked for a public employer like the state, the city, the federal government, if you're a teacher. So you are also eligible if you are caring for a minor dependent child who is under a mandatory or precautionary order. So it doesn't have to be just you. It can also be a child that you're taking care of who has COVID-19 and has the requisite documentation. So you're not entitled to paid sick leave just if you don't feel well. If you have a headache, if you're not feeling well, you can't just take the COVID-19 paid sick leave. You have to have specific documentation from your local health department stating that you are under a precautionary order or mandatory order of quarantine. If you cannot get that order from your local health department, and I'm sure a lot of you are wondering, where is my local health department? What is my local health department? You can get your doctor to sign an attestation that you are showing symptoms of COVID-19, or that you have, or that you in fact have it. And then but you do need to try to get in touch with your local health department for 30 days to try and get that order. And then once you've gotten that order, that precautionary or mandatory quarantine order, you then will know how much paid sick leave you're entitled to. So private employers with less than 11 employees and less than $1 million net income in 2019, they are not subject to this new law. They unfortunately are not required to provide this new paid sick leave, so you can submit for the normal paid family leave or disability benefits instead. And we can talk about that in more detail if that comes up. And then if you work for an employer that has more than 11 employees, you get 5 paid sick days. If you work for an employer that has 100 or more employees, then you get 14 paid sick leave days. And that is the same thing for public employers. So if you, again, work for the state, city, if you're a teacher, you would get 14 days of fully paid sick leave under this new law. Then, as I stated before, for the documents that you need to get this paid sick leave, you do need that order or the attestation from your doctor. And then you also need to fill out 2 forms, which you can get on the New York governor's website that has the paid sick leave documents. And so you fill out those, and then you give or mail you're probably going to mail them at this point to your employer, those 2 forms, as well as the documentation, after making copies for yourself. And then your employer is supposed to return them to you within 3 business days. Obviously, that's a little difficult, but the law takes these difficulties into consideration. So it understands that there will be delays. Then actually getting paid happens through your employer's insurance carrier, and you will get the benefits, or you will be notified that your claim has been denied within 18 days of you requesting the paid sick leave. And there are a bunch of ways to figure out who your employer's insurer is. You can ask your employer, you can look it up online, or if you think your employer doesn't have an insurer, you can just request your sick leave to the New York State Workers' Compensation Board, and we have that address there on our blog. So very common questions we expect today is, are you going to be fired because you asked your employer to take the 5 or 14 days of leave because you have this mandatory or precautionary order? And the answer is no. Your employer cannot fire you or retaliate against you in any way because you took this leave. Obviously, your health, the health of others is very important, and it's now the law that you're entitled to this leave. So you cannot get fired. Another question we think will possibly come up today is whether your employer can require you to use your existing sick leave or other accrued paid time off, PTO days, for a COVID-19 quarantine order. And the answer to that, again, is no. Employers are now required in New York to provide paid sick leave during the COVID-19 quarantine, and it has to be separate and apart from other PTO days that you've accrued. So I think we will wait to see if there are any other questions about paid sick leave, but also happy to answer questions about the federal law as well.
Great. We have some couple questions in here now. I think Hillary may take on, and we'll keep moving along.
Great. So the first question that we have here is, can you request unemployment pay due to COVID-19 if you requested sick pay from your employer? So this, I hate to give the lawyerly answer, but it depends. If you requested sick pay from your employer and your employer is giving you paid sick leave, so if you're home, you're getting your normal income, and you're still employed by your employer while you are either in quarantine or you're recovering, then you're not unemployed, and so you would not be eligible for unemployment benefits. However, if you requested paid sick leave and your employer did not give you paid sick leave, which you need because you have COVID-19, then you would be eligible for unemployment benefits. Well, actually, let me just clarify. First, you should be eligible for paid sick leave based on the laws that Julia just explained. And second, if you can't work, right, and if you're not getting paid, then you should fill out an application for unemployment insurance, because if you are in quarantine and can't work and are not getting paid because you're suffering from COVID-19, you are eligible for the new unemployment benefits. And when I say new unemployment benefits, one way that might be described on the unemployment insurance website is called pandemic unemployment assistance. So I've been using those terms. I'll be using those terms kind of interchangeably. That pandemic unemployment assistance is the new type of unemployment insurance that's been promulgated by the CARES Act.
I'm going to take on, at least in the first instance, the second question that we received, which is, what if a physician advises to remain in isolation to prevent from contracting COVID-19 due to an infant or minor family member being at high risk for the illness? For example, if this family member has an underlying respiratory condition. So I will, with respect to the new laws, I'll let Hillary and Julia take that on, but I did want to point out, this is an example where an existing law may be applicable in this situation. So if you've received, there's a law, federal, state, and local law, all of which prohibit discrimination against individuals who either have a disability or who are associated with individuals who have a disability. And what's important to understand is that the term disability under these laws is not the same as what we use it in the colloquial sense. Medical conditions often can be disabilities. And to the extent that you are asking your employer for an accommodation, let's just say to work from home or to be in isolation, and the accommodation is related to your need to take care of or your association with someone who has an illness that would be considered under the law a disability, and the employer refuses that accommodation or terminates you for making that request, you may have a claim against that employer for a violation of those disability discrimination laws. And a lot depends on how reasonable the accommodation is, what the type of impact it would have on the employer. But this is an example that I wanted to just jump in with to highlight an existing law that could potentially cover a situation like this question. And happy, of course, to have Hillary or Julia add to that in any way.
Yeah, so I can just address that. If a physician is advising you to remain in isolation, the physician may give you a precautionary. You may be entitled to precautionary order of quarantine, and the physician would have to attest that you are entitled to this order, essentially. So, also under the federal it's called the Families First Coronavirus Response Act, FFCRA, you are entitled to leave if you're caring for a child whose school or place of care is closed, and you get a certain amount of paid sick leave for that under the federal law. So you may be able to stay home and remain in isolation to take care of your child under either of those two options. You would obviously have to talk to your physician about getting the proper attestation.
And as far as that implicates any unemployment insurance benefits, you could be eligible for unemployment insurance benefits so long as you cannot remain in isolation or self-quarantine and still telecommute or telework. If your job requires you to go to the physical location and you have a physician telling you that you need to quarantine given your circumstances, then that could make you eligible for the pandemic unemployment assistance. Great, and I can start on the next question. So we were asked, I was laid off on March 6th, filed unemployment insurance shortly thereafter, but I haven't received any payments yet. It is still pending. What can I do to receive my money faster? So unfortunately, the Department of Labor has been just completely overloaded with applications, and people are finding that there are enormous delays in receiving their unemployment compensation. Unfortunately, there isn't too much to do. One thing that you can do is to call the claim center and just confirm that there's nothing wrong with your application that would be holding it up. Please do note, though, that all of the unemployment insurance payments are going to be retroactive. So while it may be difficult to wait for that paycheck, at least you can have the peace of mind in knowing that just because they're taking longer to process your claim, that doesn't mean that you're losing out on money because they need that extra time to process the claim. Okay, and then I see the next question is it typical to wait this long for payments? It really does depend. Some of these claims can be very fact intensive. It can take the Department of Labor a few weeks to if they need to do any investigation, then it may take time for them to investigate the claim and to issue a decision. So they don't just receive a claim and then rubber stamp it. There's usually a review process just to make sure that you are in fact eligible. And that can take a couple of weeks. And like I said, given the enormous amount of applications that have come in, the Department of Labor is definitely taking longer to process these claims than they ordinarily are. However, they are still continuing to process claims, and they've also set in special guidelines for individuals who have not yet claimed benefits to help reduce the influx of claims. So if you look online, they ask you to please wait to fill in your application depending on the day and the first letter of your last name. So if you look online, they have if your last name starts in a certain letter bracket, then you should file on certain days. And then they invite anyone who hasn't filed on those days to please file on Thursday and Friday. So if you apply on the day based on your last name, that should also help them process your application faster. All right. There was also a question that was not in the live chat, though, that I did want to address, which is whether or not you can receive unemployment benefits if you're self-employed. So traditionally, if you are self-employed, then you cannot generally not be eligible for unemployment benefits. However, with the new law, the new pandemic unemployment assistance program, you may be eligible for benefits. And so the way to do that is you need to fill out an application for unemployment benefits first. And then if you are denied, then you can go ahead and submit your application under the pandemic unemployment assistance program. And at that point, if you are eligible and self-employed, then you can start receiving unemployment assistance.
So we just got a question in. Oh, this is good. So we just got a question in. Can you be fired for not reporting to work when you're considered an essential worker as a music therapist? And I will cede the floor to Hillary and Julia here, but I will say in advance of this question that this is an example of where the law is really still being quite fleshed out with respect to the regulations that have just been passed and what constitutes under the law an essential worker is something that is sort of yet to still be defined. But Hillary and Julia both can provide some good resources in connection with the question like this.
Sure. So I guess the first question is if you're unsure as to whether or not your employer has correctly determined that you're an essential employer, there are a number of different resources that you can check. And the Department of Labor actually recently issued guidance on who is an essential worker and who is not. Unfortunately, the executive order that defines or categorizes who is an essential worker and who is not is extremely broad and really is subject to interpretation. So we're seeing a lot of different interpretations kind of across the board as to whether certain categories of employees are considered essential or not. However, even if you are an essential employee, if your employer cannot, well, I guess let me take a step back. Generally speaking, an employer cannot terminate an employee because of a medical condition. They cannot discriminate against an employee and terminate them because they suffer from a medical condition or a disability. That said, if it depends on why someone is not reporting to work. So if you are an essential employee and you're not reporting to work and you haven't been diagnosed or you aren't exhibiting symptoms, or a medical professional hasn't told you that you need to self-quarantine, or you're not the primary caretaker for someone who is suffering or who now can't go to school, for instance, and you're not providing childcare for them, you may not be eligible for unemployment benefits, and you may not have the protections under the new paid sick leave and the new protections specifically regarding COVID. And I can let Julia supplement this as well. But generally speaking, people cannot, the law is not intended to provide people as a precautionary measure to avoid going to work if they're concerned about having COVID. It's really intended for individuals who have been affected, who have been diagnosed, or who are exhibiting symptoms, or who are caring for someone who is exhibiting symptoms. And that's the general basis and the general purpose of the law.
Yeah, that's right. I mean, that's basically it. You can't just not show up to work, obviously. If you are an essential employee, you have to have a reason. And if you want to get your days paid for and get paid sick leave, then you have to be under a mandatory or precautionary quarantine. Now, under a precautionary quarantine, you don't have to have symptoms of COVID. You can be asymptomatic, but you do have to have returned within the past 14 days from a country designated a level 2, 3, or 4, which I don't know what the US's designation is at this point, but that is one way that you could be asymptomatic and get a precautionary quarantine. Or of course, you could also be caring for a child that has an order of quarantine. Now, under the federal law, the FFCRA, you can take off 12 weeks under this law and you get your 2 weeks of full paid sick leave, followed by up to 10 weeks of paid expanded FMLA leave. And that would be if you're caring for a child whose school or place of care is closed. And that would mean that you don't have to tell your employer that you're sick, or you don't have to have that quarantine order in place, and neither does your child. You just have to prove that you're caring for a child whose school or place of care is closed. So those would be some ways that you, as an essential worker, might be able to not go to work. But under the New York law, generally speaking, you do have to have an order of mandatory or precautionary quarantine.
The only thing I just want to jump in and say to add, and this goes with respect to everything that we're talking about today. I mean, what we are here to do is do our best to explain the law and explain the way that the law is changing, and the way in which the law can protect people who have lost their jobs or who are in untenable or uncertain employment situations. But I want to make very clear that in no way are the answers to any of these questions or our explanation of the law an endorsement of the law, so to speak, or a viewpoint from us that we think that this is the right or wrong law. So certainly someone who is concerned about leaving their home, regardless of whether they're classified as essential, that is a completely legitimate concern. And perhaps it should be the case that the law should allow people to be protected in those circumstances without the extra circumstances that Hillary and Julia just discussed. And certainly we're not saying that it's right or wrong for the law to be the way that it is, but we want to try to give people the best information we can about what their rights are. And I just wanted to make sure that that was clear.
Okay, and I see that we received a question concerning someone who is concerned about their immigration status and how that might affect their eligibility for unemployment benefits. So unfortunately, we wouldn't be able to advise on that issue. However, there is a toll-free number for the Department of Labor. It's a hotline that you can ask, and the Department of Labor's website explicitly says that if you have questions about your immigration status and whether or not you're eligible for unemployment benefits, then you can contact that number. So I'll have that put into the chat momentarily so that you have that resource. There may also be other resources, but that one is at least directly through the Department of Labor. All right, and there's another question that I can address here, which is if you've been unemployed since 2019, obviously pre-COVID-19, do you qualify for unemployment benefits? So this again also depends. If you may be qualified for unemployment benefits depending on when you last worked, how much you earned, how often you were working, and why you lost your last employment position. So these would be the normal questions that one would ask if they're eligible for unemployment benefits. And you can definitely go on the Department of Labor's website to take a look at who would ordinarily be eligible for unemployment benefits. Now, if you've been unemployed and you've been seeking work and now it's been particularly difficult because of COVID-19, then you may also be eligible under the Pandemic Unemployment Assistance Program, which has extended the amount of time that someone can be eligible for unemployment benefits. So I would definitely take a look at the New York Department of Labor's website. There's something called a claimant's handbook, and you can go through that and get and look at who would ordinarily be eligible for unemployment. It would be someone who was recently employed, who was earning a certain amount of wages on a weekly basis, someone who is an employee and who lost their job for a reason not of their own fault, meaning they weren't meeting employment standards, or they had to or they were terminated because they were being laid off, or terminated for a reason that was not their fault, like the company was downsizing, or their position was eliminated, or some reason other than misconduct. So you may still be eligible for unemployment benefits.
Great. I'm just going to answer. I see we have a question. Do small businesses get to opt out under the FFCRA for paid leave due to child care reasons? So under the FFCRA, the guidelines, by the way, on the FFCRA still haven't been published. I think they're due, says sometime in April 2020. But small businesses with fewer than 50 employees may qualify for exemption from this requirement to provide leave due to school closings or childcare unavailability, if the leave requirements would jeopardize the viability of the business as a concern. However, the disability laws, which we talked about before, which are part of the anti-discrimination laws, might be implicated in the event that you or a family member has a medical condition, and that medical condition would fall within the definition of a disability under the anti-discrimination laws. So obviously it depends on what the disability is, or what the reason is that you're staying home to care for your child. But those laws would definitely be implicated.
And just to add to that, this is another example of where the law is not yet sort of fully formed. So if you look even, and I'm going to try to do a screen share here. I'm pulling up here the DOL's website with respect to this specific act. And if you look at the DOL's own answer with respect to this small business exemption, the DOL says to elect this small business exemption, you should document why your business with fewer than 50 employees meets the criteria set forth by the department, which will be addressed in more detail in forthcoming regulations. So you have another situation here where there will be continuing updates to the law to help establish these sorts of exemptions. So we don't, right now, we don't have any pending questions, but we're here for another 45 minutes, so we're happy to answer any additional questions, and hopefully some more will come through. We had mentioned a few times a couple of different laws that pertain to people who need to take leaves or who could potentially be covered by the anti-discrimination laws related to disabilities. And so I figured I would just speak about that for a few minutes here. There are two things to discuss, really. There's a law called the FMLA, which is the Family Medical Leave Act, which provides individuals the ability to take unpaid leave but not lose their jobs for a period of 12 weeks to deal with certain types of medical issues and issues concerning family members who are going through medical issues. And the law provides the right to any employee who works for a covered employer, and usually those are employers with more than 50 employees in a given location, and the employee will have had to have worked for that employer for some time. But to the extent that the employee is covered, they have the right under certain circumstances to take 12 weeks of leave unpaid. However, their job is protected during the unpaid leave. And so someone can take this leave to deal with a medical situation and return to work, and the law requires them to be placed in the same position or one that's substantially similar to the one that they held when they went on leave. So it may be that individuals who are experiencing COVID-related issues may be covered by the FMLA in addition to the laws that we've been discussing today. And I've also mentioned a few times the anti-discrimination laws as it relates to disability. Now, understand that, again, disability under the law is not the same thing as disability in the colloquial context, in the way that we would use that term in our daily lives. There are different definitions under the various laws. There is a federal law called the Americans with Disabilities Act, and that law provides for a pretty tight definition of disability. The state law in New York provides for a looser definition, and ultimately the city law provides for the most expansive definition of disability. So if you are living in the city or in the state of New York or even outside of New York, and there's a medical condition that you're experiencing or that your family's experiencing, and you ask for some accommodation from your employer to deal with that medical situation, or your employer terminates you after you've disclosed that situation, you may have a claim against your employer for an unlawful termination. And I guess an additional piece of information to understand is that this applies even where you don't actually have a disability, but your employer thinks that you do or perceives you to have a disability. So we've received, for instance, as a firm, we've received calls from individuals who have been terminated or who have been let go from their employment because they coughed in the workplace. And the employer all of a sudden believed, even though it wasn't true, that an individual had a disability, potentially COVID or potentially another illness, and that individual was then terminated. So you also are protected even if an employer erroneously believes that you have a disability. So under the FMLA, so there are different laws that cover this. Under the FMLA, as it is originally constituted, the FMLA does not provide for paid leave. So the FMLA provides for leave that's unpaid. You may have, and this may be where the 60% is coming from, unless it's something that has been passed, in one of this new package of laws that Hillary and Julia can talk about. But what often happens when people take FMLA leave is that they also go on disability. And so if your employer has a short-term disability policy or a long-term disability policy, and you take FMLA leave, it is not uncommon for a disability policy's general, but as a matter of general rule, to pay out 60% of someone's compensation pursuant to that policy. So that's not an uncommon scenario, which may be where that number comes from. And I'm certainly not suggesting that there is no way to be paid for any or part of that time. As we've been discussing, there are certainly laws that would require your employer to continue to pay you to the extent that you fit within the new paid leave laws, to the extent that you have a COVID-related issue on the new sick leave laws, et cetera. So there are circumstances in which you can continue to be paid, and there are insurance, policies that you may be able to apply for, and other, paid. New York also has a separate law called a paid family leave law. And so there are other ways in which you may be able to receive payment, but under the FMLA, the law does not require individuals to be paid. So while we wait for some more questions to come in, I think what I'd like to do is speak a little bit more generally about employment law and about what we do as a firm and the way in which people can approach situations where they've lost their jobs. So as most people listening have probably heard before, as a general proposition, unless you have an employment contract with your employer, your employment relationship is at will. That's a term that's relatively commonly used. And hold on one second. We have another question coming in. So Matthew, that's a good question. So we have another question coming in. The question is, what if in response to an accommodation request, your employer puts you on an unpaid leave of absence? The answer to that depends. And as we've said that a lot today, I'm sure it's frustrating, but if you're looking at the discrimination laws, the anti-discrimination laws as they relate to disabilities, an accommodation request has to be granted by an employer to the extent that it is reasonable. So an employer is required to consider and provide reasonable accommodations to deal with individuals who are asking for accommodations for disabilities. And the employer is required, and this is something that our firm has litigated quite frequently and essentially created this theory of the case, that an employer is required to engage in what's referred to as the interactive process, which means that an employer cannot ignore the fact that someone has a medical condition or a disability or refuse to have a discussion about that. So an employer is obligated to participate in a discussion about reasonable accommodations and obligated to provide reasonable accommodations. So if I'm an employee with a disability or medical condition and I'm asking my employer for a paid leave of absence, or I'm asking my employer for some lesser accommodations, such as, I need a chair that is more ergonomically efficient because I have back issues, or I need to take off 2 hours every week to attend certain doctor's appointments. So let's say I'm asking for an accommodation of that type and my employer says, no, I'm putting you on unpaid leave. Well, the only way that would be legal for an employer to do under those circumstances would be either A, if you weren't disabled, or if you weren't perceived to be disabled. And so that's a pretty narrow set of circumstances in which the employer could be protected. Or B, if the accommodation that you've asked for is one that's unreasonable in light of the company's ability to provide it. So if you had a situation where, it's a two-person company or 5-person company, let's say, and your role is critical and you ask for a month off of paid leave, that might not be reasonable under the law to provide. However, if you are working at a company where there are 10 people that do the same job that you do, and you're asking to take off an hour a week to go to the doctors, and you're a salaried employee, under those circumstances, it might very well be unreasonable for the employer to deny the accommodation. So in answer to your question, if the accommodation that you've requested is reasonable, the employer should provide it. In addition, if the employer is just putting you on unpaid leave because you are ill or because you have a disability under the law, that is an adverse action that would be unlawful unless the employer could again establish that there was either some other reason that they did it or that you could not actually do your job because of the circumstances that you were facing. So in most circumstances, if you've exhibited medical conditions or disabilities or your family members have, and your employer takes an adverse action, that's certainly something that you might want to consult with counsel about. There's one more question that I'll cede the floor to, and then I'll circle back to the general employment laws.
Great. So we received a question asking self-employed people are being told to apply online and they are being instructed to call in to complete the process. Calling in is pretty much impossible. Any advice? So the reason why self-employed individuals are being told to go through this process is because they're generally not eligible for regular unemployment benefits, but they could be eligible for the pandemic unemployment assistance. And so unfortunately, there is not, to the best of my knowledge, there's not a way of completing that last portion for self-employed individuals online. The Department of Labor website does say that they tend to get fewer calls on Thursdays and Fridays. And so today is Friday at 2 o'clock. I would probably try to call this afternoon because you'll have a better shot of getting through this afternoon than you will maybe on Monday morning. That said, what you can do is you can just call and then I've heard a lot of people who just put their phone on mute and they go about their business, have it on speakerphone so that you can hear the background music and just wait until someone picks up. It might take a while, but to the best of my knowledge, that's still the only option for someone who's been given the instruction to call because they're self-employed.
Thank you, Hillary. So as we wait for additional questions to come in, I did want to speak a little bit more about the general employment laws and the idea of recessionary discrimination and companies using tragedies and global either recessions or market crashes or unemployment circumstances to justify or to conceal unlawful conduct. And so, as I had mentioned earlier, the laws, even before COVID, make unlawful the termination of an employee or the demotion or the pay cut of an employee or other adverse actions on the basis of that employee's gender, age, pregnancy, disability, race, national origin, ethnicity, sexual orientation, religion. There are a number of different categories of protection that people have. And what we see a lot in circumstances where a company does layoffs is that they use layoffs to terminate people that they otherwise wouldn't be able to terminate because it would be so obvious that what they're doing is unlawful. So we've had circumstances, for instance, in which we've represented 5, 6, or more women in cases against big corporations who went through a massive layoff, but we were able to establish by looking at the data and the statistics concerning that layoff that those women, that a significantly greater proportion of the women were terminated than men. And so we were able to make the case and the argument that the layoff in that situation was actually used to conceal gender discrimination. We have situations where a layoff is supposedly occurring and it's only a few people that are terminated, and they're all people who have made complaints, or people of color, or people who have recently been pregnant or had medical issues. And so to the extent that you've been terminated in connection with the global pandemic, I don't think it's fair to just assume that you were the victim of bad luck. It may be that you were the victim of bad luck. It may also be that you were the victim of an unlawful decision to choose you in this crisis rather than someone who is more deserving of termination. And so if you are within one of the protected categories that I identified, if you have been making complaints at work, whistleblowing, if you have been sexually harassed and you have rebuffed those advances, to the extent that you fit within any of these categories, it may be beneficial to you to consult an attorney.
Thanks, Mike. And we just received another question. If you were receiving unemployment that recently ended, how do you find out if you're eligible for an extension? So that can depend on a number of circumstances. When you say that receiving unemployment that recently ended, so that can mean one of two things, right? That could mean your unemployment ended because you started at a new position, and so you were no longer unemployed, and so were no longer eligible for unemployment. Or it could be ended because you've exhausted the amount of unemployment benefits you could receive, which previously was 26 weeks. So if you're talking about the latter, meaning that you were receiving unemployment and you continued to receive unemployment until you exhausted the amount of unemployment that you received, then what to do next, according to the Department of Labor's website, is it depends on when your last unemployment benefits check came in. So according to the Department of Labor's website, it says if you've exhausted your 26 weeks of benefits after July 1st, 2019, so in the last few months, the Department of Labor's website says you should go on the New York Department of Labor's website, sign in, and file a claim for unemployment benefits. And what might happen is that you may be denied unemployment benefits and then given the information to apply for the pandemic unemployment benefits. Because remember, that's how it's working. It's that you still need to apply for the traditional unemployment benefits and then potentially get denied. And then if you're denied, then you have the opportunity to apply for the pandemic benefits. So according to the website, which I'll have our moderator put in the live chat, what it is instructing you do is to log in and to file and to apply online.
So we have a question here for an employee needing to take leave because his or her child is out of school closure due to COVID-19. Are the first 2 weeks covered under the sick leave at a max of 200 a day and the rest of the 10 under the expanded FMLA at the same rate? So under the FFCRA, individuals are covered if they have to take care of their children due to school being closed because of COVID-related reasons. And under the law, they receive 2 weeks of paid sick leave. And it depends on your employer, but that would be 2/3 of the employee's regular rate of pay, so whatever that is. And if you work, and that has to be because your child is at home, and then you get the additional 10 weeks of paid expanded family and medical leave at 2/3 the employee's regular rate of pay. And you also have to have been working for at least 30 calendar days at that employer to receive that leave.
And with respect to the second issue, FMLA leave certainly could apply. Again, that's generally unpaid. So what I would suggest is also considering an application for paid family leave under the New York law, which is distinct from the new paid sick leave situation. So if I just share my screen here, if you go to the New York website for state paid family leave, there is a section here for employees that describes how to apply, what the eligibility is, and then what the benefits are. And this is a paid leave for a period of time. So you may consider FMLA, you may consider the paid family leave as well. In terms of there's a question about whether the employers are going to get a tax credit for this, and that is a question that we can try to circle back on next week in a discussion a bit more potentially about how this impacts employers. For now, we're just focusing on employees, but I appreciate the question for sure, and we'll try to get back to that next week. So we got about 25 minutes left here, and happy to answer any additional questions to the extent that anyone has any. So I'll give a few minutes for that. And if not, then I'll speak a bit more about generally what people's options are in circumstances like this.
Okay, and we just received a question, and it asks, are part-time employees eligible for UI benefits? Say if you were working 20 hours per week while being a student. And this is for part-time employees who were laid off due to COVID-19. So part-time employees can be eligible for unemployment benefits. What you should do is, well, it depends. If you were working 20 hours per week and you're no longer working, what you can do is you can apply for unemployment benefits. You may have been eligible for the initial unemployment benefits, so it's possible that you can still certify under that. It's also possible that you will be denied unemployment benefits and then given the information for applying to the pandemic unemployment benefits. But part-time workers, certainly, assuming that you were in fact working, a certain number of hours and making the requisite wages, because there are minimum wages in order to be eligible for unemployment benefits, you very well may be eligible for either traditional unemployment benefits or the pandemic unemployment benefits.
Great. And we just got another question in here. It is a person who gets a doctor's note to remain at home for 14 days due to the person having symptoms of the coronavirus. And in this letter, it is explained that the age of this person, as well as the history and years of frequent and serious respiratory infections, put them at a serious risk. This is someone who worked in an outpatient facility at a hospital, but was forced to move into the inpatient section with some corona virus patients being treated. And there were certain exceptions offered to the individual not to have direct contact with coronavirus patients under certain circumstances, but that person does not meet those circumstances. And so the question is, if that individual gets terminated because they fear going into work, is there any possibility of eligibility for unemployment benefits? And I will, Hillary is our unemployment expert, so I'll allow her to answer that. But I did have one point to make. In a circumstance like this is precisely the type of circumstance that I'm describing, where an individual may have asked for a reasonable accommodation to deal with a medical situation. It's not just the fear of getting coronavirus, but also exhibiting coronavirus symptoms, and even perhaps more importantly, sending a letter to the employer documenting their age and previous serious medical issues. So this is an example of someone who gets terminated who may have a claim for discrimination under the federal, state, and local disability discrimination laws. And I will let Hillary answer the question with respect to unemployment benefits.
Yes, so based on the law, you should be eligible for unemployment benefits if you're in a quarantine that has been recommended by your medical provider. Then that you should be eligible for unemployment benefits if you're terminated as a result. Please note that you might also be eligible for paid sick leave. And Julia can speak a little bit more about that, but based on the new laws, you probably would be eligible for paid sick leave. And I'll turn that over to Julia.
Yeah, I was just going to say, if you have a doctor's note saying that you have to remain at home because you are displaying COVID-19 symptoms, then you are essentially having a doctor attest that you meet one of the criteria, which is that testing is unavailable to you, but you're symptomatic and you probably have COVID-19. So once you get that doctor's note or attestation from your doctor, you can provide that to your employer, who should then give you, whether it's 5 days of paid sick leave or 14 days, depending on your employer size, but you should be getting that paid sick leave. And of course, you do have to continue to call your local health department to get the order. But in the meantime, that doctor's note should provide you with that amount of paid sick leave, so that it shouldn't go straight to termination.
Okay, and we've received a couple other questions. One is a follow-up to a previous question, which says, my unemployment insurance just ended on March 8th, exhausted 26 weeks. I understand there's a possibility to be extended 13 weeks. Am I just supposed to reapply from scratch? Thank you. So here, I can pull up, I'll do the screen share, and I can pull it up in just 1 second. But essentially, it'll depend on the prompt for when you apply for unemployment. So when you sign into the Department of Labor, you should have your own account. And when you go to the Department of Labor's website, you should be able to sign in. And when you sign in, it will give you instructions. But there is, and I can pull up, assuming that I can, let's see. Sorry, just having some technical difficulties. Okay, no, it's not working. But if you go on the Department of Labor's website, and I believe our moderator has sent you to it, it explicitly says that you need to log in and then fill out an application. So the Department of Labor should have prompted an application for you depending on your status and your eligibility. But to the best of my understanding is that you are essentially starting from scratch as far as filling out the application goes, because the Department of Labor needs to know where have you been working, what have you been doing, have you made any earnings, what is your unemployment insurance rate going up or down. It's possible that if you've earned more, then that might actually, in the interim, then that might affect what your benefits are. If you've been employed by another employer, that might affect which employer is responsible for the unemployment benefits. So that's why they're making you start from scratch, so to speak. But after you sign into your account, you should see an application for you to fill out. And then there's another question here that's also a follow-up from a previous question, which says, are the pandemic UI benefits on a separate site than the regular UI benefits? I've been trying to apply through New York State Department of Labor. So it is not a separate site. The way that it works is you still need to apply for the traditional unemployment benefits. And then they will make a determination as to whether or not you're eligible. Even if you know going in that you're not going to be eligible for traditional unemployment benefits, but you will be eligible for the pandemic one, you still need to go through the application process. And then after they have reviewed your application, they will then give you instructions for applying for the pandemic unemployment insurance benefits. So it's not the most streamlined system, but it's the way the Department of Labor has it set up, at least for now.
All right, so perfect. Another question came in here. Okay, so this is a question, it's a two-part question. First part is, my wife is a social worker at a mental inpatient unit. They're asking the social workers to work elsewhere in the hospital on the medical side. And I think the presumption is that they'll be at greater risk of potentially contracting coronavirus. And the question is, can they be made to work in this more risky and dangerous location? And the other question is, to the extent that there is someone at home who has a history of illness that puts them at a high risk, is that something that could potentially change the analysis, and where this individual has asked to work remotely, not in the more dangerous situation, and that request has been denied. So this is another situation where you would have potentially a claim for disability discrimination to the extent that accommodation is being requested because there is someone at home who is ill, and the accommodation is, I have someone who has a history of illness at home, and because of that, I'd like to continue to do the work I'm already doing and not be moved into another location. It's conceivable that denying that request could constitute a failure to reasonably accommodate someone who has an association with someone who's got a disability or medical illness. As a general proposition, and I'll let Hillary and Julia discuss the new laws, apart from that circumstance, an employer can require an employee, for the most part, to work in any sort of situation that the employer so chooses. So as a general proposition, to the extent that your employer is asking you to do a job that's different than the one that you have, and they're asking you to do that for a reason that's unrelated to gender, age, pregnancy, disability, race, sexual orientation, et cetera, if that employer is requiring you to do something different, and you don't have a contract that says that you only are, required to do X, Y, and Z, unfortunately, there's not much you can do to avoid being moved. Now, that said, the new laws may help provide at least some protection or some degree of pay for some time off to the extent that this situation arises, and Hillary and Julia can speak to that.
So under the federal law, you do, and under the New York law, you do have to have some sort of order or some advice from a healthcare provider to quarantine, or you have to be caring for a child who is at home or under a quarantine order. So unless for this specific situation, unless there's a note from a doctor stating that your wife has to be quarantined or has to be taking care of you because you've been exposed to COVID-19, this would fall into one of those categories that Mike was talking about, where the law is not really clear. The new laws aren't really clear on what someone in that situation would do. And I'm sure the situation is arising all over the place because there are plenty of people with comorbidities and other autoimmune issues that are at much higher risk for getting coronavirus, and their partner or significant other might be an essential worker who has to show up to work, just like this example, in a hospital or at a grocery store, and is very likely to possibly bring home the virus with them. So unfortunately, the law has kind of been silent for this scenario. And I think hopefully it'll be addressed soon as to what people in these types of situations can do, other than what Mike said, request an accommodation under the disability laws.
Right, and the same goes with the unemployment benefits law. Right now, it's pretty broad, the language, and it's a little unclear as to whether you can get unemployment benefits because you lost your job because you were taking precautionary measures that weren't necessarily required by a medical professional. So I would definitely, maybe tune in next week, because perhaps more guidance will be provided by then. But as of right now, it's a little unclear as to whether or not, unless you've been told by a medical professional that you need to self-quarantine, and that has been certified, it's unclear as to whether or not you would be eligible for the pandemic unemployment benefits. And since we have a minute, I wanted to bring up a chart on my screen share. So here, give me 1 minute. I can pull this up. So this is a chart that the Department of Labor has put out, which I think is really helpful. And so it answers a few of the questions that have been asked about what to do. So as you can see, pretty much the first step across the board is to apply for traditional unemployment benefits. So if you're eligible for regular unemployment benefits, if you're not traditionally eligible, or if you have exhausted your unemployment benefits since July 1st, 2019, then the first step is to apply for unemployment benefits. And then you can kind of follow this flow chart. It's available on the Department of Labor's website, and I can send it in. I can have our moderator send it through to our live chat. But this is also pretty instructive as to what steps you need to take if you may be eligible for the pandemic unemployment insurance. Okay, and we received, and maybe Mike wants to take this over, but we received a question that's very fact intensive, and we may need additional information from this person concerning taking COVID-19 enhanced FMLA leave to care for your now at home children a few hours daily while you are yourself working from home. Is that intermittent FMLA leave under the existing DOL regulations? So that, I think, and unless Mike or Julia want to answer that, I think it might make sense for you to contact us through our contact box and just give us a little bit more information about how large your employer is, how many hours you're working from home, what requests you've made for FMLA leave, and then perhaps we can either answer it during the week or at next week's session.
Yeah, and just to jump in on that, so and we're coming to somewhat to close to a close here. I want to pull up from our website here our contact page, and the moderator will put a link to this contact page in the chat over there in the YouTube. But if you want to contact us, there are a number of ways to do that. You can just contact us directly. If you go to the firm's website, you can click on contact, and you can see here there are two ways right now to contact us because we're not in the office. We're working remote. There's the main number here, and then there's the contact@wigdorlaw.com. You can feel free to do that. And then if you want to keep up to date with what's going on at the firm, you can feel free to connect with us on social media. But if you'd like to contact either myself, Hillary, or Julia directly, if you go to our firm's website and under the firm tab, you click on team, you will see the attorneys here at the firm. And if you click on any of our profiles, I'll click on mine, for instance, you will have an opportunity to see that you can email. Under each of the photographs, there's an email link. So if there's any questions that have not been answered to anyone's satisfaction, or that questions come up that we don't have the answers to right now because of laws are changing, or anything that you've heard today that makes you think perhaps you would like to have a more in-depth conversation about your situation, absolutely feel free to reach out to myself, to Hillary, or to Julia directly.
Great. And our moderator just put our contact information in the live chat as well. So if you want to take a look there, then you are welcome to contact us at any of the email addresses or the phone number provided. And we are still, even though we're working remotely, our phones are fully operational. We are fully operational. So you can please feel free to contact us either by phone or by email.
The other thing that would be helpful, perhaps, because I know that there are individuals who probably, may not want to ask questions in this sort of context and may simply want to, listen and hope to learn something. But, to the point that I was just making, if you have questions, you can certainly feel free to contact us directly. And if there are things with respect to what's going on right now, or with respect to employment generally, that you'd like to hear about, send a message to either one of us directly or to the contact box and let us know what topics you'd like to hear about. Because as I noted at the beginning of this, we're going to be doing these seminars on a weekly basis from now into the foreseeable future. And we'd like to make sure that people have the information that they need. And to do that, it would be very helpful if we were to receive emails from anyone that wants specific topics discussed, and it would give us some time to look into those issues as well. We've got about 5 minutes left here, so I'm going to wait a moment to see if we have any final questions. So if you do, please get them in.
And in the meantime, I can show you the Department of Labor has put up some information about how to get this medical certification that Julia has been talking about. So this is for obtaining an order for mandatory or precautionary quarantine that we've discussed. So if you go to this website, then you can find the information about what you need to do, what kind of documentation you need to obtain in order to qualify under some of these laws, right? Because in a lot of circumstances, the law doesn't say, it doesn't allow you to say, I know I'm high risk, I know I'm vulnerable, so I should just be entitled to stay home. A lot of these laws do require you to take that next step and actually get certain documentation showing that you are part of a vulnerable population, or that you should be staying at home for your own safety or for the safety of those around you. So we can share this as well in the live chat, but the Department of Labor has provided guidance for you to obtain the documentation that you need to be eligible under these laws.
Yeah, and I'll just add that the documentation you need under the New York COVID-19 paid sick leave law would also suffice to get the FFCRA sick leave. So it is dual. If you get that doctor's attestation and then you follow up with your local health department, that should work for coverage under either law.
So we are winding down here with about 3 minutes left, and it looks like I'm gonna give it another minute to see if there's any last second questions that we can help answer. But in the meantime, as I had mentioned, I would encourage anyone who has any additional questions, or at 2:33 after we get off the line here, when someone thinks about that question that they couldn't remember when we were on, to reach out to us directly, to reach out to our contact box, or to reach out through our main number. We want to be here as a resource for people during these times. There's a lot of uncertainty. There is a lot of fear and anxiety, and obviously employment is something that we spend much of the time in our lives working on and doing. So we want to be as helpful as we can to anyone who's going through a bad time right now, or anyone who just has questions about what might happen for them in the future. And with that, I think I will end this, as we're coming down to 2:30 and we don't appear to have any additional questions. I appreciate, and I know that as a firm, and on behalf of Doug and the entire team, we really appreciate everyone who participated here today. Hopefully this was helpful to everyone, and we look forward to seeing you all here hopefully next week. And Hillary and Julia can say their goodbyes as well.
Same. Thank you all for those who participated. Hopefully we were able to help. And if you have any friends who have any questions about applying for unemployment or eligibility or paid sick leave, or what their rights might be under the law, please let them know that we're doing this on a weekly basis, or you can have them contact us directly if they're more comfortable. You can also email us a question for us to discuss next week, and that's fine too. So we wish everyone the best of luck. We know this is a really tough time, and thank you for helping us make sure that the community is as aware of the resources that they have as possible.
Thank you, everyone. We really hope we were helpful, and we really look forward to answering more questions and providing more guidance in the coming weeks, as I'm sure many new laws, executive orders, and such will be passed. So we'll be brushing up, and we'll be really happy to help in these difficult times.
Thanks, everyone, and have a great weekend.